Welcome to Concepts in 3 minutes or less. In this video, we'll be continuing our look at legal issues. I'm not a legal practitioner, so the following should be considered opinion only. If you want to review the legislation yourself, use the links shown. Software developers have access to sensitive information, and they have a lot of responsibility. Backdoors are often in place for debugging, but these can be exploited or left in accidentally. Database access is essential for testing, but can lead to data breaches, and even the most careful of us write code that an evil actor can exploit. Be aware too of using the works of others. The acts referenced in the study design are both state and federal. Pause for a moment to take in which is which. Pause also to review the applicability of each act. Note especially the Privacy Act 1988. The Health Records Act has broad applicability as shown here. Note the consent and de-identification exception for researchers. This is significant and is referenced in the Privacy Act 1988 as well. The Victorian Charter of Human Rights and Responsibilities 2006 provides for the basics of human dignity. Other jurisdictions have equivalent, of course, but this one only applies to the Victorian government and Victorian public authorities, not private companies or individuals. Only sections 13 to 15 are noted in the study design because your code must consider these. Your program should be secure and private, free from bias, and respectful of the right of expression. The rest of the Act applies to fairness of trial, presumption of innocence, equality under the law, etc. Section 10AB of the Copyright Act 1968 regards a computer program as a literary work. Thus, code is protected, but look and feel and algorithms are not, though they may be patented. Icons and images are protected as works of art, but fonts are a grey area. Lastly, copyright protection prevails until 70 years past the author's death. Perhaps consider classical music as an example. The Act tries to negotiate fair dealings for authors and consumers, generally meaning a reasonable proportion. It also covers works to be used for commentary. Attribution is the act of acknowledging your source, and it is very important. License agreements are a key pillar of the legislation. And the Act allows for backups too, but only for the purchaser or as part of the technical workings of the software. The legislation has teeth too. The highest penalty I found was 650 penalty units, and at $192 each, that equals a fine of $125,000 for individuals plus jail time. I certainly hope that was helpful. Thanks for watching and keep an eye out for more over the coming weeks.